All right. So the trial is all about testimony, right? So that means you're going to have your testimony down. And it's never too early to start writing your script for the story that you're going to tell the judge while you're on the stand about why the judge should give you what you want the judge to give you. So start writing your questions out, not only for you, but for your witnesses. And also be sure and start writing cross-examination questions for the other side's witnesses. I did a video a long time ago that I probably should redo. Check this video out on cross-examination to figure out how to cross-examine your witnesses. Now, your trial time is going to be limited, so stick just to the relevant questions that are going to prove the issue that you need to convince the judge should be ruled in your favor. Don't go off on tangents. Don't go all over the place. Be direct, be focused. And having a script prior to trial is really going to help you feel more secure. It's going to help you come across clearer to the judge, and it's going to help you present everything that you want to present. Don't just show up in court not knowing what you're going to say. Get those questions written out. All right, so now that you have your questions all written out, it is time to cross-reference your documentation, your exhibits against those questions. So go through your script of questions and right next to the appropriate questions, denote what exhibits match up with those questions, what exhibits are relevant to the questions that you're asking. So this is my process. I write my pretrial statement. From the pretrial statement, I use that as an outline, and then I flush out each part of the pretrial statement and write questions for each section of that pretrial statement. And then I go in and I add the exhibits that are going to support the points that I want to make. You have to do this. This is such an important part of preparing for trial, because if you prepare the questions and then you can't find the exhibit that doesn't go with the question or match that section or prove what you're trying to prove, and you're going to fumble in the courtroom, you're going to waste time, you're going to run out of time, and you're not going to prove your case. You got to have the exhibits with page numbers, with paragraph numbers teed up and ready to go so you can point right to them during your direct testimony when you're asking the other side, during cross-examination when you're asking them questions, and also when you're asking your own witnesses questions. All right, so next thing to do when you're 30 days out from your trial, take your scripts, take your exhibits, and get with somebody who loves you and who you trust and who's going to be supportive of you, and start practicing your testimony with that person. You got to get ready for the courtroom. I'd like to tell people that your trial is the Super Bowl of your case, and that means you have to practice. Just like athletes would not go into a big game without practicing and preparing, you have to do the same. Prepare your testimony, refine your testimony. If you have an hour to present your case, then make sure you can testify in an hour. And if you can't, cut and refine and make things more efficient. You can do it. I do it with my clients all the time. I always rehearse with my clients at least once prior to a big trial, usually twice. And we go through all the questions I'm going to cover, and we include cross-reference to the exhibits. And many times we have to cut questions. Many times I have to tell them, shorten your answers, you're being too long-winded, but practice makes perfect. And you want to do as good as you can when you're going into this big trial, which could be the trial of your life. So next tip, when you go into your trial, especially if you have an attorney on the other side, then they might object when you testify or try to testify. They might object to questions that you're asking of your own witnesses or of the other side. The attorney or even the other party might object when you're trying to get evidence admitted during your trial. You have to be prepared to meet those objections. And there are a lot of rules of evidence that govern evidence and testimony in the courtroom. That would take a whole semester of law school, which is how long I had to learn it. And I'm still learning these rules of evidence every day, and we don't have that in this video. So what I would say is get really familiar with relevance, the rule of evidence concerning relevance. Type it down, write it down, Google it, and study it. Any testimony or any evidence you want to present has to be relevant to the issues in dispute. Also get familiar with the hearsay rules if you can. And there's a lot of exceptions to the hearsay rules. So hearsay is when somebody is saying that somebody said something. That's hearsay. If I testified, well, John told me, that's considered hearsay. So look at the hearsay rules of evidence, type it in, and try to get a little bit familiar with hearsay. And if you're going to try to elicit hearsay or admit a piece of evidence which is considered hearsay, there very well could be an exception to that rule which might allow it in. Look at hearsay. And finally, take a look at the rules of evidence when it comes to authenticity of a piece of evidence. In this day and age of AI and really cool programs like Adobe, it makes it easier than ever to forge things like pictures, like documents, like evidence. And I'm seeing an increase in the amount of fake items that people are trying to give to me to give to a court. So if you're admitting a piece of evidence or you want to try to admit a piece of evidence, you have to show the court that this information, this piece of evidence is authentic and that it is what you're saying it is. So look at the rules of authenticity, because when you're trying to admit a piece of evidence, you have to show the judge why it is what you say it is. And in particular, look at text messages. How do I show a text message is authentic if I'm trying to admit it at trial? Or email messages. If I were trying to admit an email at trial, put it in Google, how would I show the court that this is authentic? And geez, with AI and with Google, it really will walk you through, but you wouldn't be prepared if you didn't at least have some basic understanding of these 3 rules of evidence: relevance, hearsay, and authenticity. And there's tons more. If you have time and if you have the motivation, and if you have more than 30 days to get ready for your trial, then by all means, have at it. So this next tip is going to make you feel a lot better when you get the logistics lined up before your big day. So make sure that you have reliable transportation. Make sure that you have childcare arrangements set, that either somebody's taking care of the kids while you're in trial, or that somebody's going to be able to pick them up from school if you're still in trial at the time that they get out of school. Make sure you know where you're going. Make sure that you know what you're wearing. Have your clothes laid out, have gas in the car, have everything ready to go. Check and double check the location. I can tell you one time the location of a trial changed and I actually went to the wrong location. Talk about major freak out attack. Not good. My client was in the right place, and by the grace of God, something happened and the trial had to get moved in time. It got delayed by an hour. So that gave me time to travel about 45 minutes from one courthouse to the other. So I got super lucky. Now I check about 3 or 4 times, including when I'm in the car, usually sitting at a stoplight, to make sure I'm going to the right place. But knowing these things ahead of time are really going to give you peace of mind so you can focus on what's important on the day of trial. All right. So my final tip is you just need to be mentally ready for the judge to make this decision. And if you are at the point of going to trial, then you have done the work necessary. You have made the decision that you're going to trial. So you really have to be at peace with, this is where I'm going. And the only thing I can control is how good of a job I do. The only thing I can control is my performance. The only thing I can control is my preparedness. And when you know those are the only things that you can control, then you really will have more peace of mind, because a lot is out of your control. So you have to be at peace with and ready to accept whatever decision the judge gives you. And it may be a fantastic position, better than your wildest dreams, or it may be a horrible decision. And I've had decisions go both ways. And the thing that you have to know is that regardless of the decision, you are going to be okay. You are going to be okay. It may seem horrible in the beginning, and even if it's great, there may be some aspect that you're not happy with, but you're going to adjust. You're going to learn to live with it. You're going to make the best of it, and you are going to be okay. So make that decision right here and now, regardless of what the judge says or does or orders. You will be okay. So those are my 10 tips for the 30 days leading up to trial. You know what you need to do. You got this. Keep on trucking. And until next week, remember to get out there and command the courtroom. I'll see you in the next video.